Okay. Good evening, everyone. This is Joshua Pondexter. My company is Stone Consultant LLC. We're an estate planning and business advisory company. This evening, we're going to be talking about estate planning. We're going to try to give you everything you need to know about estate planning in 30 minutes. So let us get started. I'm going to share my screen. And if you would, just mute yourself. All right. So this one here is 4 ways we mess up our finances, how to avoid them. And it's a condensed version of my longer workshop, which some of you guys attended, 8 ways we mess up our finances, how to avoid them, how to avoid those ways. Probate, not avoiding probate, not avoiding joint tenancy, not avoiding federal estate taxes, taxes on Social Security benefits, just taxes completely, right? Taxes is a real drain on our wealth. 50 to 70% of our income exposed to taxation. That's both federal, state, sales taxes, excise taxes, property taxes, business taxes, taxes. So taxes are a big deal. Need a tax strategy, how to, reduce those. We help in there. Inflation, right? Inflation is a real deal. We have to deal with market risk, nursing home costs, and not planning. So those are 8 ways that we can mess up our finances and not avoid, and we want to avoid those. So first of all, we're going to deal with the number 1 mistake is not planning to avoid probate. And as always, we get into the definition of what is probate. Probate is the legal process in which the court makes sure that after you die, your will is legally valid, your debts are paid, and your assets are distributed according to the instructions in your will, right? So a lot of people under the misconception that if you have a will, you bypass probate. No, a will is a invitation for probate because the judge has to approve it. The courts, it goes to the court system, right? And then if you have some debts, they're going to pay your debts, and then they're going to distribute your assets according to your will. If you don't have a will, you die intestate. That means that the state that you reside in have their system of distributions, right? And they normally try to go through a bloodline channel. But in our community, bloodline ain't the way that we call family. Somebody taking care of us in our later years, they might be family. We might want to leave them something. So we don't want to go to probate for people to say who our family is, right? Why probate? If your name is on title of an asset and you die, the only legal way to take your name off title of an asset and put the new owner name on is probate. So that's what the probate process is. You die with your name on your house, your car, your stock, your bonds, your checking accounts, your boats, your second home, all these things you have, you still had your name on it. So probate is just a process, legal way of taking your name off and putting the new owner name on, i.e. your spouse, i.e. your children, your grandchildren. Those would be the people that you would want your assets to go to, right? So what assets go through probate? So we got to look at what will go through probate: certificate of deposits, real estate, businesses. A lot of people are strictly unaware that their business will go to probate. So, hey, you decided, you retired, you want to start a business, you build that business up to $300,000, $1 million revenue generating business, and you want to pass that on to the next generation. You need to have it so aligned that it doesn't go into probate. Stocks go to probate. Bonds go to probate. Mutual funds go to probate, right? Personal property go to probate. Surprisingly, not every asset you own must go through probate. If you own assets jointly or have a valid beneficiary or own life insurance products, or use a trust. Those assets will avoid probate. Trust held property, avoid probate. We want to talk about that and a little bit about the revocable living trust and how we can utilize that to avoid probate, right? Okay. The probate process, right? A petition for probate to begin. So you got to petition the court and pay a fee, of course. The court takes control of supervision, right? So now when you petition, now the court's going to take control of the assets, the house, the cars, the stocks, the bonds, all those things that we say are ours. They're going to take control of. The judge approve your will and officially appoint your executors, right? So the judge is going to approve your will. They're going to look at your executors. They're going to say, well, I named my child, I named this person. Then there's a fiduciary test to see if that person can stand the test. So, well, now that person might have too much debt. That person might live too far away. And so we can't have that person be an executor. So we're going to move them out the way and we're going to put one of our lawyer buddies up. All right. So you go to probate, they got a whole system of disallowing the executors that we select, right? Oh, the executor got bad credit. You can't be a fiduciary with no 500 credit score, all right? So big problem. Pay your final bills. Final hearing notice to settle. Disputes are settled and assets are distributed. So you go to probate court, people can file disputes, right? You know, brothers and sisters, uncles and aunts. Anybody said, well, hey, you know, my uncle said he was going to leave me that Cadillac, right? No, my auntie said she's going to leave me that fur coat. So all these disputes can arise in probate. Executors release and file close. So this is the probate process. And I think I kind of mentioned last time that 53% of the probate cases that are messy takes about 550 hours to settle. That's a long time, right? For an expensive $300 to $600 an hour attorney, right? So the cost, here's what's wrong with probate, right? The cost, an average of 10 to 15% of your estate. So you have a $500,000 estate, that's $50,000 going to get taken off in probate. Will or no will, probate. Time delay, 6 months to 2 years. The family had lost control of those assets. ARP study estimate it's a $50 billion a year in probate fee. That's what the courts get, with 20% of the state being consumed by attorney fees. That's a lot. That's a lot to go through the probate process. I could tell you that Prince died without a will. He had $126 million estate. The federal government got 48%. The state of Minnesota got 13%. The lawyers got another 20%. What did his heirs get? A little bit of nothing, right? So that's why they hurry up and sold his catalog, right? That's why they got those immersive shows about Prince. You know, his family members didn't put that on. They sold it to a group of lawyers who bought the boy estate, right? Public domain. This is the problem. This is what problems wrong with probate. Family lose control, right? And we don't have to have a Prince estate, but if we're 1,000 there, we don't want to send it through this process, right? So probate. Probate is to be avoided at all costs. Agreed? Any questions on probate? Okay, we'll keep pushing on then. Probate is impersonal, not something that we want to do. Not planning to avoid the pitfalls of joint tenancy. Mistake number 2. Estate planning disaster. Joint tenancy, one of the most common forms of holding title to assets, lead to an estate and financial planning disaster for you and your heirs, right? Husband and wife, this is normally how we hold our assets, right? Your cars, your houses, your business, we generally hold them like this, right? Let's see, did I get all of those out the way? So what are the advantages of joint tenancy? Avoid probate. Assets held in joint tenancy, there's no requirement for a formal probate. So that's a good thing. It's convenience. Accounts can be withdrawn at death or managed during a capacity by the joint tenant. So if my spouse's name is on my checking account, I need my bills paid, they can continue to pay them where I'm in the hospital or I become incapacitated for any reason. So that's one of the 2 of the advantages of joint tenancy. What are the disadvantages of joint tenancy? Well, loss of control, increased liability, assets may not reach your children, potential tax penalties, both gift tax penalty, estate tax penalty, capital gain tax penalty. So let's look at in our modern world of marriage, divorce, and remarriage, this become a big issue, right? So you have some people, they probably got together in their 20s, stayed together to their mid-50s. They got divorced, they got their own stuff, right? Then they get remarried again. Who you want your stuff to go to, right? What I mean by loss of control is that now, if you have another spouse on your stuff, they have 100% control, especially if you name a child, right? If you put a child on your house, you put a child on your bank accounts, you put a child as a joint tenant on any of your assets, they have control. They can go in there and get 100% of the money, right? Or they're not going to do that because they're a good child. That's why you put their name on it. What's going to happen? But they married to someone, right? And that spouse has an accident, gets sued. Now is going to sue that spouse. That's the wife or the husband is joined to that person in that lawsuit. So now they're going to go looking for all the assets that's in that estate, right? So mama, daddy, whoever assets that are tied to that child, they up for grabs. Loss of control, increased liability, right? Both legal and financial. Assets may not reach your children, right? Marriage, divorce, remarriage. Hey, we love all the children, but we love our children the most, right? So what happens is that mama dies. She lives $1 million to her daughter, and her daughter's married with her second marriage, and the child is overcome with so much grief because mama died, they died, right? Who's that money going to? That husband, right? And them children don't belong to that husband. What the husband gonna do with them children? He gonna find the nearest relative and bring them back, right? So these are real life, real world situations that could happen with the dangers of joint tenancy. There's more efficient and elegant ways to pass our assets on to the next generation, right? We're talking about penalties. So gift tax penalty, the gift tax we talked about last year, last section was $17,000. Next year is going up to $18,000, right? So you put your child name on your house, right? And it's $100,000 house. You have effectively given them a $50,000 gift. And so anything over $17,000, it is a capital gain tax, right? Because you gave them 50 grand, but you didn't pay it. So If Uncle Sam call you on it later in life, there's penalties involved with that, right? So there's some serious disadvantages to joint tendency. Any questions on joint tendency? Not something that we really, really want to do, right? We don't want to be naming people on our assets because that's not the best estate planning process. You know, there's better ways to do that without incurring the loss of control, increased liabilities, and things of that nature. All right, we're still pushing on.
I have a question real quick.
Yeah, sure.
So with the joint asset
Joint tendency.
Joint. So basically, the way I hear what you're saying, you really, really gotta trust that person, or you want that to whatever you have built up to go to them.
Yeah, you do. You really, really want to trust that person, and you really, really want what you have to go to them. But that person has another person attached to them that you don't want your stuff to go to them. Yeah, you really, really, really want to, you know.
Right.
You really, that's why you did it. Yeah, but there's better ways to do it. Not planning for the overwhelming cost of long-term care. So what are the odds of us going to a nursing home, right? Recent studies indicate that 1 out of every 2 people who reach the age 65 will spend some time in a nursing home, right? Not very good statistics. You know, I would say what you need to do is do what Blue do, is eat an apple and go to the gym every morning, right? Stay healthy. And we talk about who will pay for these expenses. Medicare, 2%, Medicaid, 42%, long-term care insurance, 2%, families, 54%, right? So we can take families out of the equation. We can add that up to Medicaid. So that's 96% that's going to be paid by Medicaid. That's a state and federally funded program. It is bankrupt in state. It has bankrupt New York. It had bankrupt Indiana. It almost bankrupt Illinois. Medicaid is serious. So Medicaid, if they have a person that goes on Medicaid, they are trying to get as much money from their estate that they can, right? So countable, non-countable things in the Medicaid spend down. So this is Medicaid asking you to spend all this stuff down before they start paying. In the state of Illinois, it's $9,000 a month. A burial plan, $2,000 to $103,000. Actually, it's $133,000. I missed my 3 there. But so what's happening? So this is a husband and wife. One of them go into the nursing home. They let you keep the home, the car, the jewelry, a burial plan up to $25,000. Anything over that, they might want to recover that from Medicaid. And then a maximum of $133,000 that can be left at the spouse that's not in the nursing home, right? So, and there's rules to this. Say, for instance, a husband and wife, the husband has been the worker, the wife has been staying at home, and so he has all the pension, all the Social Security coming in. So he has his $6,000. Each state has a portion that they will leave to the spouse that doesn't have income. So I think in the state of Illinois, it's roughly about $3,200. Then they take the rest, right? But say those 2 spouses have income coming in, they're going to take the one that goes to the nursing home, take all their income, and then the spouse that's left out in the community could never, ever, ever accumulate any more than $133,000 or Medicaid is going to be like, oh, you can pay this bill now, right? We'll let you pay it. So what's countable? Okay, they always come for the cash first. Stocks, bonds, anything they can liquidate, mutual funds, vacation homes, cash investments. And there's a 60-month look back, which is 5 years. So what this tell us is that we should get our planning done 5 years before we go to the nursing home. But we don't want to go to the nursing home, right? No, we don't. And we want to have other strategies of having someone at home, or most folks say, well, I'm gonna take care of my mom if I can, and my dad gonna move in with me. But the nursing Medicaid spend down has become so insidious. It's very difficult to get around all these rules without gifting your money away. And you really don't want to do that because you don't know how long you're gonna live and how much of your money you have to stay, right? So is paying $10,000 to $20,000 a year for long-term care insurance policy the only answer? No, it's not the only. Truckload of money going out every day is not the answer. There's other ways. I think that if this is concern for you, you should avail yourself of our complimentary consultation to talk about Medicaid planning. But let's talk about, what about the revocable living trust? Because we said trust held property, avoid probate. So what is it? It's revocable. I mean, you can tear it up. It's amendable. You can make changes to it. So it's not the irrevocable or the irrevocable one, because you can add assets to it. You can make changes. Trust held property, avoid probate. So whatever you put into your trust, it secures additional tax benefit at death. One of the best things, the best way to transfer real estate is by a trust, right? Because you bought the property for $100,000. It grew to $500,000. That's $400,000 of gain. And if you just transfer on death, or you just let it go to probate, your child is going to receive a $500,000 value, which they're going to have to pay $400,000. They're going to pay capital gains on that $400,000, 20%, which is about 80 grand. So once you put it into the trust, you get what's called a step-up basis, right? So instead of just being your parents' $100,000, they step it all the way up to the $500,000. So there's no gain that's due, no capital gains that's due on that real estate inside of a trust. So that's one of the great advantages of a trust. Also, beside the fact that it doesn't go to probate. So you can have control after death. You can determine when things are distributed to the heirs, right? In a trust, it's a box. I liken it to a box. You have the trustor or the grantor, which is you. It's put together by your power. You're the trustee. Whatever you put in the box, you manage it. You're the beneficiary. So, you have a husband and wife together. They put a trust together. They are the guarantors. They're the trustees, and they're the beneficiary as long as they're alive. And if one passed away, it just goes to the next one. And then you have successor trustees. That's kind of like an executor in a will, but with this one, the judge don't have to approve this person, right? This person distribute the assets according to the trust. They don't get to make any changes or any of that. They just kind of make sure that those assets go to the people that your wishes are, right? And then you have heirs. That's your children, your grandchildren, your charities, wherever you want your money to go. And so that is a trust, right? Revocable living trust. Any questions on the trust? Any questions on trust? Nope. Okay, good. So now, when we look at estate planning, we have we look at estate planning. Let me get where I need to want. We have a process to help us plan our estate. There's some documents that are created in your estate plan. So let's talk about really what a estate plan look like. If you guys are able to see this, right? So in my estate planning documents and my services, we do Medicaid planning. We look at your assets, see what's exposed to Medicaid, how we should disposition those assets to protect them from Medicaid spend down. We talk about tax reduction strategies, right? Looking at your tax liability, avoiding probate court and attorney fees, so the planning and how to avoid double taxation on IRAs, 401ks, and pension plan. Because whenever you transfer an IRA or 401k to a non-spouse, you're going to have what's called double taxation, right? So then we have the documents that we create for that. Your revocable living trust, liken a trust to a company. It's its own entity, right? And one of the things that's beautiful about trust, they're private and confidential matters, and so no one gets to know what's going on in the trust but the people that create it or whoever you want to let know. That's why we also create a memorandum of a trust. That's for the children, for the financial institution, for the medical institution that needs to know that a trust exists, right? So then we create doable general powers of attorneys, right? So husband and wife should have one, because you can't talk to the Social Security board, you can't talk to the pension people, you can't talk to military retirement if you don't have these powers on one another, right? Doable power attorney for health care, right? So who's going to speak on my behalf when I'm incapacitated, right? Who's going to say no? I talk to my spouse, I talk to my husband, my wife, and I know that they don't want that type of care, right? So I have the power to say no to that. Medical information disclosure authorization, number 5. Sad to say, the leading cause of death in America is physician mistakes. Doctors killing people in the hospital. So the last thing they want to do is let those medical records are loose, right? So this is pretty much a whole harmless letter to the medical institution that says, hey, release my medical records to my family, to my estate, right? The living will, the right to die, do not resuscitate, right? The pourable will, one of the most powerful documents in the package, because when you're still gathering the assets and you might not get it into your trust, it'll pour over into the trust and don't go through a prolonged protracted probate process. Statement of wishes. You can, let people what you wish for them to do, your funeral service and stuff like that. Number 9, assets transfer informational guideline. Sad to say that 80% of the trusts that are created go unfunded, right? So what that means is that no assets are transferred. You just got an expensive piece of coffee table ornament, right? So we go the extra step and we create those transfer documents, warranty deeds, right? To transfer real estate, bill of sale of personal. All your personal stuff is a probatable matter. Your jewelry, your fur coats, all the things in your watches, everything that's in your house, right? Bill of sale general, we could use that to transfer boats and cars and businesses into your trust. CDs, insurance, bank letters, securities, and stock transfer. So we have a complete package that we offer to our clients. And one of the things that we want to let you know is that on average, the average cost to do, this is on the low end, a trust and transfer one piece of real estate in the state of Illinois is $2,500, right? Now, when you add those ancillary documents, powers of attorneys, they can go from anywhere from $300 to $600 a piece, right? So you see all those extra documents, and they can add up. And for a single person, that package can balloon up to about $5,000. For a family, it can balloon up anywhere from up to about $10,000 to do those services, right? And so this is why we keep those costs really affordable, right? For a single person, I charge $3,000. For a family, I charge $4,000. And with the code word Nadine, you're gonna get the church discount, 10%, right? Till the end of the year, right? We're running that special. So I really try to keep my time. So so with that said, we want to let you know that you can contact us, JoshuaPondexter.com, to schedule an appointment. There's no, we took that fee off of there, so you can schedule an appointment without having to pay a fee. And if we have a private consultation, you want to get your documents and get your plan in order, for attending the workshop and using that code word Nadine, you will get that 10% discount. Once again, YouTube, Facebook, LinkedIn, like, share, comment. Until now, we're going to say bye for now, and we'll see you on the next one.